brothers and sisters, and friends, and I see some enemies. In fact, I think we'd be fooling ourselves if we had an audience this large and didn't realize that there were some enemies present.
But we were just, for this practice one, the suggestion was go through that list of questions and see how you do with them.
Okay.
Just to practice.
Okay.
All right, Mr. Jamar, you are here today because you've been charged with speeding 56 miles per hour in a 55-mile-an-hour zone. This carries a monetary fine of $500, as well as a requirement for you to take a defensive driving course should you be found or plead guilty. So all I need from you today is a plea of not guilty, in which case we'll go ahead and set you up with a trial date. A guilty plea, in which case you will have to pay that fine and take the defensive driving course. Or a plea of no contest, which will have the same penalties as a guilty plea. So all I need from you is one of those three answers: guilty, not guilty, or no contest.
Okay. Your Honor, I intend to plead guilty today. I just had a few points of clarification.
Okay, well, what do you need clarified on so we can go ahead and get that plea in for you?
Okay. Do I have the right to a fair and meaningful hearing, sir?
Well, of course you do. Why would you think otherwise?
I would just like to have these questions answered so I can just make sure of that.
You waiting for an invitation? There's not a green light.
Okay. And also, do I have the right to be informed as to the cause and nature of the charges, allegations, and proceedings here today?
Well, of course you do. You have every right to be informed as to the cause of these charges against you.
Okay. And also, am I presumed innocent of all the charges?
Stop.
Okay.
What did I say? Did what I say match your question?
Okay, that wasn't a yes or no. It was a sure. I guess clarification.
No, it's not even. It was a sure.
No, it was you have the right to be informed of the cause.
Oh yeah, cause. There you go.
Oh, just the cause. Okay.
Yeah, just the cause of the proceedings.
Okay. Also, do I have the right to be informed as to the nature of the charges and proceedings here today?
Why, yes, you do.
Okay. And also, am I presumed innocent of all charges against me here today?
Absolutely, sir. You are absolutely, just as everyone else that enters this courtroom here. This courtroom here, everyone is presumed not guilty of all allegations against them.
I guess objection, point of clarification. Am I presumed innocent of all the charges against me here today?
And that's fine, but I like to take it a step further. Objection, point of clarification. I was trying to ascertain whether or not I'm presumed innocent, not whether or not I'm presumed guilty.
Okay.
So I'm identifying where he purposely misled, and then I roll that right back into the question. So I've identified, the error in his response. So now I'm going right back into it.
Okay, I got it. Okay. Objection, point of clarification. I just wanted to be clear with something here. You said that I am presumed not guilty of the charges against me here today. And I asked you, am I presumed innocent of all charges against me here today?
So am I presumed innocent? Yeah.
Okay. Yeah. So am I presumed innocent of all charges here against me here today?
Why, yes, sir, you are.
Okay. Also, am I presumed innocent of every element of the charges?
I'm sorry, what was your question again?
My question was, am I presumed? Oh, sorry. Am I presumed innocent of every element of the charges?
Why, yes, sir, you are.
Okay. Well then.
Now, sir, I've entertained lots of your questions. Now, and can I please just get a plea for you, or are you just going to refuse to enter a plea today?
Well, my intentions are to plead guilty today, but I just had a few other questions I'd like to ask and clarify before I enter my plea. I just want to be informed.
Okay. Future reference, try not to use the word questions, but yeah.
Oh, okay. Okay, so
and also don't wait for him to give you permission to continue on. Just go right into your next sentence. Always end on a question mark.
Okay. Is jurisdiction an element of the charges?
Mr. Jamar, I can assure you that this court already has jurisdiction. Otherwise, the prosecutor wouldn't bring such a case before us. And obviously, since you were in the state of British Columbia, we have jurisdiction. So let's go ahead and move on to your next question.
Okay. Well, has the objection, point of clarification, has the
yeah, don't answer that with an okay.
Sorry. Has the prosecution provided the evidence to show that this court has jurisdiction to impose upon me?
I wouldn't even let him slide that much. I would go right back to the objection point of clarification, and I'm just asking whether or not jurisdiction is an element of the charge or not. Because if you do that, he's already derailed you from your question, and now you've abandoned that, and now you're lacking a critical confession from the judge.
It's like, no, I didn't ask you for a conclusory statement. I asked you for a yes or no.
Okay. Should I say that, or should I just...
No, being that direct would piss him off, but
yeah.
I'm just pointing it out.
All right, then objection. Is jurisdiction an element of the charges?
Mr. Jamar, I've already told you we have jurisdiction, and just move on. Why do you keep persisting on repeating yourself?
Objection clarification. You say that you have jurisdiction, but the question I asked is jurisdiction an element of the charges, and you haven't answered. So is jurisdiction an element of the charges?
Yes.
Okay, so since you've stated that I'm presumed innocent of every element, does that extend to the element of jurisdiction?
Yes, of course it does.
Okay, then what evidence has the prosecutor submitted to show that the court would have jurisdiction to oppose on me?
Now, Mr. Jamar, I've been on this bench for 25 years. In all my 25 years, no one has ever dared to challenge this court on such a trivial matter. Now we're not here for you to make all kinds of allegations against this court, thinking you're not subject to it, talking like some sovereign citizen. No, all I need from you today is a plea of guilty, not guilty, or no contest, and then we can just move on. Okay?
Well, objection. A point of clarification. I asked, is that a yes or a no to the question I asked? What evidence has the prosecutor submitted to show that this court would have jurisdiction to impose on me?
Well, I think you're a bit confused because you just asked me yes or no to a question that is not a yes or no question. So maybe you need a little bit of time to consult with an attorney, since obviously you don't have a very good grasp of these proceedings. So what we're going to go ahead and do, we're going to give you a public defender.
Objection.
What? Objection what?
I I represent myself. I don't need any representation.
Oh, okay. You're waiving your assistance of counsel. That's just fine. All right. So what you're going to need to do from here on, Mr. Jamar, since you have just waived your assistance of counsel, we're just going to go ahead and schedule you for trial. Enter this not guilty plea on your behalf in order to what? What?
My intentions are to plead guilty today, but I haven't. Or what evidence has a prosecutor submitted to show that the court would have jurisdiction?
Okay, time out.
Okay. All right, I'm a little nervous, but yeah, go ahead.
Okay, time out. I just told you waived your assistance to counsel and you didn't object to a goddamn thing.
Okay.
Yeah, you're not waiving your assistance to counsel. You don't want a public defender, right? For other reasons.
But you're not waiving your right to counsel. Do you know what it means when you waive your right to counsel?
No.
It means that now we get to hold you to the standards of a lawyer.
I could argue against that myself.
Yeah,
but,
you could argue against
I'm
it.
I'm not interested in waiving any rights until after I've been informed. That's the key.
So yeah, and don't go. You're not representing yourself.
Yeah. Unless you know what that means. If you know what that means, I'm all ears. I've been trying to figure it out for good 16 years, 17 years. So. We're being brutal, by the way. Keep in mind, we're being brutal. Standard disclaimer, we're being brutal to toughen you up, not because we're mean people.
Yeah, so, I mean, you never say that you're representing yourself, okay? Because you don't know what that means. I don't know what that means, right? And also, you're not trying to waive any rights. When you say you're representing yourself, they're going to take that as, just like I did, that, oh, you're waiving your assistance of counsel. Okay, that's great. Okay, moving on.
Yeah, might come up that you do turn out to want one. You never know.
Yeah.
So would I say I don't need a lawyer for my own defense?
Well, ask him.
No.
Ask a question. It's like, would I need a lawyer to be informed of the cause and nature of these proceedings and plead guilty here today? Is that a requirement? There's all kinds of questions. I'm just coming with one off,
Do I have to get a lawyer to get the prosecutor to state a case? Is there a case?
Yeah. Or you can simply put it off with we can do, I can, well, I'll figure out the lawyer bit in a second here. I'm just trying to figure out the answer to my question first, which is, you repeat your question, I mean, any topic that isn't cool, you can say, okay, we'll pick that one up right after I get the answer that's on the table,
Okay, now when I object, would it be just objection, and I wouldn't have to say point of clarification? I would just stop the conversation right there. And
just saying objection by itself means nothing but I don't like that, and it's a really, really weak thing to say. Okay. I mean, objection can stop a sentence in order to give you a moment to review your notes and so forth, but a lot of judges will knee-jerk reaction, not let you even give the grounds for your objection, but say overruled before you even say what you're objecting to. But then again, that's a topic for discussion as well. It's like, I'm sorry, are you completely uninterested in the grounds for my objection and want to overrule me no matter what the objection is about? So what I'm objecting to is completely irrelevant to you trying to overrule it. And that itself looks bad too, right?
Judge, what if my objection here was the only way to get at justice? Would you still overrule it?
Yes, I would, because America.
I mean, for all he knows, your objection could be, objection, there's a kidnapper who took my daughter and whatever. He doesn't know. It could be anything.
All right. So, I mean, as far as the whole assistance of counsel thing goes, the easiest way to just wave that away is say, objection. At this time, I'm not seeking a public defender. I just need to be informed so that I can make such determinations. Because without being informed, right, you don't know what kind of lawyer you need.
Well, I mean, you'd know generally,
and they'll,
you know vaguely what kind of a lawyer, but you wouldn't be able to really interview them super well without knowing all the details.
Well, we read you the charges. That's all you need to know.
Yeah. Yeah, most people also choose a lawyer pretty randomly, don't they? They don't interview for nothing. If you were really trying to interview a lawyer, and you were a good little statist and so forth, you would get all of the evidence that you could, all the details, so that you could talk to lawyers and discuss all the details and see if they were knowledgeable about such issues. But no, people tend to interview for a damn. If you were put in charge of hiring somebody as the new cashier at McDonald's, you'd probably have more questions than people generally do when hiring a lawyer. Yeah, I guess people don't think about the fact that they should interview their lawyer kind of rigorously, even if they choose that lawyer.
All right, so So let's get back into it. Oh, so you're waiving your assistance of counsel. That's great. Well, we can certainly enter that into the record.
Objection, sir. Point of clarification. I did not say I'm waiving my right to, my counsel. I'm just trying to. I basically just trying to find out and become informed of the nature and cause of the proceedings, so I can be better informed, so I can make a plea.
Is there a question mark at the end of that? Come on, man, end on a question.
So, what evidence has the prosecution submitted to show that the court would have jurisdiction to impose upon me?
Well, sir, don't you have that ticket right there in front of you?
Objection. Point of clarification. How is the ticket evidence of jurisdiction?
No. Okay, so that's going to be a good question here in a minute, right? But right now, if the judge points to the ticket and says, don't you have the ticket, right? Then you want to clarify what he's saying. So are you saying that this is the only evidence of jurisdiction that the prosecution has submitted?
Or this contains, or this references, or this.
Yeah. Are you saying this document, describes the only evidence of jurisdiction that the prosecution has submitted?
He didn't say anything. He asked you just incidentally, do you have a copy of the ticket?
Yep.
If you went on a rant about it, he could say, I wasn't saying it was. I was just asking if you had a copy of it. Why are you going all off into the bushes over it, right?
I wasn't listening carefully enough.
Right. They're playing word games, right? So be careful of them.
So I mean, my first thing would be, a point of clarification. Are you saying that this document contains or describes the only evidence of jurisdiction that the prosecution has submitted? Because that's what he's inferring, right? But you want him to state it clearly. So let's try it again. Well, you got the ticket right there in front of you, don't you?
Objection. Point of clarification. Are you stating that the ticket I have in front of me is the only evidence that the prosecution has submitted to show that the court has jurisdiction to impose upon me?
No, of course we're not.
Okay, then what evidence of jurisdiction has the prosecutor submitted to satisfy their burden of proof?
See, and right there, the judge is in a bit of a bind. So he's either got to point to something else, which, if that's the only thing there to point to, it's like, he's got to deflect, or he's got to go on a rant and threaten you. Right, so he's in a corner.
Move the goalpost now to the geographical area.
Yep.
Well, on the ticket it says you're within the county of bullshit, and the officer will testify to that at trial.
But you notice what that answer that Gabe just gave you? He didn't say that it was or was not.
Okay.
He didn't answer the question. He just misdirected.
Okay. Would I object to that, or would I just...
I certainly would. I would get him to either commit to or abandon the ticket.
Okay.
I'd say objection, point of clarification. I just asked if you're saying that this ticket describes the only evidence of jurisdiction that the prosecution has submitted. It's a simple yes or no.
What if I just said, objection, point of clarification? Was that a yes or a no? Would that be too in your or
What was your? It's too easy to forget the question if he's muddying
Yeah.
water up a little bit. So, I mean, if you want to say that, is that a yes or no to the question, and then restate your question? Restating the
Okay.
question is not a bad thing. I know it's rude and common, common just conversation, but you're trying to make it clear that you're asking multiple questions and they're just really being elusive. So, I like the idea of saying it exactly the same repeatedly when they're not answering it,
Okay. Okay, so objection. Point of clarification. What evidence of jurisdiction has the prosecutor submitted to satisfy his or burden of proof? Or sorry, was that a yes or no?
It's
to the
not really
question?
that's not a really yes or no question.
Okay.
But I realize that you're reading it and it wasn't given as a yes or no, probably.
Okay.
I like baby steps. I like asking if he's submitted any at all. Has the prosecutor submitted any evidence of jurisdiction? Makes it yes or no. He kind of combined it up into what evidence, which is still the same sentiment, the same thinking.
The question you should have been re-asking is, since I had identified the ticket earlier, or I mean, you could go all the way back to that one, fine. But I like to go back to the ticket because I want him to say yes or no on the ticket, so we can either keep going with the ticket, or we can just ignore the ticket entirely because it doesn't matter.
Okay.
So if he says yes, okay, we'll keep going with the ticket. If he says no to the ticket, then, well, the ticket was irrelevant to your question.
Okay. So if he keeps going with the ticket, then are we just breaking it down then? Like just trying to figure out what part of the
Yeah.
ticket?
Yeah,
Okay.
yeah, but we first need to get him to commit to the ticket.
Okay.
Because if he doesn't commit to the ticket, there's no point in tearing apart the ticket. Because all he's going to do is he's going to point to something else, and then point to something else, and then point to something else, right? You want him to commit to anything. Then you can tear that thing apart.
What if he said it? What if he said it's not the only thing?
Well,
What if the judge said it's not the only thing? It's like, okay, so it is one thing, right?
yeah,
Well, then we can attack it still.
yeah. Then we can attack it still, right?
Yeah.
And then
So then
after
you can
we've
say, what was the other
finished
thing?
attacking it, yeah, and saying, okay, well, we've already dispelled the notion that was one of the things you said it was. What are the other things?
Mm-hmm. Tasty little crackers. They just crumble. So let's see. So where are we at? You were at objection, point of clarification. Maybe I didn't ask my question loudly enough so that you could hear it clearly. But the question I was asking was a simple yes or no. Is this the only thing that the prosecutor has submitted to establish that this court has jurisdiction to impose upon me?
So right there, it's, clear exactly what's going on, right? That you either didn't hear his question or ignored his question or something, right? And so he's asking it in very clear terms, hey, what's the answer to this?
Mm-hmm. Yeah,
It's
and then,
nice and confined. It doesn't presume anything outside of what's already occurred in court. You're not asking about the universe. You're asking about something that occurred in his purview, right?
Yeah.
So he should be able to answer. He should, he doesn't have an excuse of I don't know. If he said I don't know, the question becomes, okay, so is this court completely unaware of where this court stands as far as evidence? Or you simply drive that wedge where it's like, okay, do you mean you don't know as in the court itself doesn't know, or you don't know you personally don't know?
That too.
Because he'll constantly refer to himself as the court and judge and whatever interchangeably.
So
It's like, okay, so you and the court are completely different on, you don't know it, but the court does, or should,
So is this dance just between like myself and the judge, or like at what point
Yes,
would be?
but the entire point of this dance is to to eventually get to the point where you can drive a wedge between the judge and the prosecutor, right? Because we keep mentioning the prosecutor submitting, right? The prosecutor doing this, the prosecutor doing that. And we're hoping at some point they'll pick up on it and be like, hey, I can pawn this off on the prosecutor.
Right.
Mm-hmm.
But the idea of bringing that judge, because that judge starts out kind of like on that prosecutor's side of the table, big time, right? Where you know, with the number one, you know, your intention to plead guilty, you're facing that, you're looking at him across the table, so to speak. And then with like as you get to number two, if you do, you know, the gun in the room issue, he's a little bit more, you know, hopefully being brought around to your side of the table a little bit, and you're just saying, hey, I'm just here to deal with threats of violence. Yada yada yada, and then you know, in a latter phase, you're starting to talk more and more about the prosecutor's failure, or that you're hoping the judge is seeing and picking up a little bit more in that prosecutor's failure. And the hopes are that he'll eventually say, "Yeah, Mr. Prosecutor, what evidence have you submitted?" Because that's a big field goal right there. And oddly enough, it's happened recently. It used to be thought of as unthinkable, but we've actually have now recordings of people doing it.
Last week. He goes up and he asks the judge, you know, what evidence of jurisdiction has the prosecutor submitted? And the judge looks at the prosecutor and says, state? And the prosecutor just sits there dumbfounded for a minute straight. And then says they'll be dropping that case.
Nice.
Yeah, he asked 2 questions and got a 10-year felony charge kicked out.
Awesome.
These results are not typical.
Yeah.
By the way.